Welcome to 3 Minutes of History. I'm your future history teacher, Chris Oxenford, and let's get started.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. Look, it obviously starts with you have the right to remain silent. I know you've heard this before. And then, I think it sounds something like, well, the thing, right. You have the right to remain an attorney.
Did you say that you have the right to be an attorney?
You do have the right to be an attorney if you want to.
You have the right to remain silent. Anything you do say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be provided to you by the court. At some point in almost every movie, TV show, and radio drama about the police, one character will read a suspect this list of guarantees. This list of rights is so ingrained in the popular imagination that even in countries where these rights do not exist, people will expect them to be read. But as little as 50 years ago, in 1966, these rights did not have to be read to you. This common warning, issued by the police, was the result of the Supreme Court case of Miranda versus Arizona, which was decided 48 years ago on July 14, 1966. On March 13, 1963, Ernesto Miranda was arrested and accused of the rape and murder of an 18-year-old girl. After about 2 hours, and despite only circumstantial evidence of his connection to the crime, Miranda confessed. Part of his confession stated, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me." However, Miranda had not been informed of his right to legal counsel. Miranda's court-appointed attorney attempted to use this fact to have Miranda's confession thrown out, but the court overruled him. Miranda appealed his case to the Arizona Supreme Court, which upheld the lower court's ruling. Miranda then appealed again to the United States Supreme Court. At the time, the court was led by Chief Justice Earl Warren, a very activist judge. Warren wrote the opinion for the majority of the court, in which he held that, quote, "The person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent, and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have a lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent him." The court then overturned Miranda's conviction. This didn't really help Ernesto Miranda, however, as he was retried in 1967 and was convicted for the crime which he had originally been accused of, this time based on actual evidence. He was eventually released from prison and enjoyed minor celebrity status, signing Miranda cards for police officers. He was killed in a bar fight in 1976. This case was controversial, with many feeling it was unfair to inform criminals of their rights. Nevertheless, the Miranda warning has become a staple of American jurisprudence since 1966. This has been 3 Minutes of History. I'm Chris Oxenford. Thank you for joining me.